We are doing a series of events each month leading up to the Ladycoders conference. This is our first one because it's January 2018, and I am super excited about this one. We have a stellar group of people here to speak today about sexual harassment, and this is really an information session. We are filming it. It's also on Facebook Live, but we are filming it so that there is posterity, because the people that are going to speak today are true experts in the field. And I'm going to introduce them. We have Surbhi Garg right here. She regularly represents companies in discrimination cases before the Equal Employment Opportunity Commission and the Colorado Civil Rights Division. She's also experienced in all manner of employment cases in state court, federal court, and before administrative agencies, including discrimination, wage and hour class actions, trade secrets, breach of contract, non-compete agreements, employment agreements, and much more. Additionally, Ms. Garg conducts trainings on sexual harassment and all aspects of discrimination. She also drafts employment agreements, employee handbooks, and employee-related policies and procedures. Clearly an expert in the field. Joining her is Neeti Pawar, right here. I love Neeti. Neeti. Neeti has many years of litigation experience in family, employment, and criminal law. She now has her solo practice, which focuses on mediations, independent fact-finding, investigations, appeals, and activism. In 2012, 2013, and 2015, she earned a spot on Colorado's Super Lawyers list of the top 50 women lawyers. She also enjoys her industry's highest peer ratings and is recognized in the publications for Best Lawyers in America and Colorado Super Lawyers. She was recognized as one of Denver's 40 Under 40 in the Denver Business Journal, and she is the founding president and current board member of the South Asian Bar Association of Colorado. Very, very distinguished guests today, and so let's welcome them, and thank you. So the way this is going to work is Neeti and Surbhi are going to speak for about 45 minutes, kind of educating everyone and all of us on the law and what we can all do with sexual harassment and what companies can be doing. Then we'll do about 15 minutes of questions, and then we'll bring up our third guest, Heather McKenzie, and then we will do another round of questions. So that's the agenda, and I will let them take it away. Oh, absolutely.
Start up? Great. Hi, everybody. Thank you for being here. This is so fun. Surbhi and I were so thrilled to be invited to speak with just a whole new group of people and different faces. And we both kind of do this in the lawyer world, and it gets, I don't know, it's just exciting to kind of break out into new circles. So thanks for having us. We are going to kind of tag team off each other, but I just wanted to get a sense from the outset. How many, I know I met some people here. How many are developers here? Like, yes. How many are employees? Employees. How many are own companies are employers? Oh, interesting. Great. Okay. All right. So just to give you a big picture. Come on in. No, not at all. Join us. Just to give you a big picture, we're going to talk about sexual harassment in the workplace. Sexual harassment, when we talk about it, is such a broad range. I mean, the umbrella and the scope of what can fall underneath this umbrella cannot be addressed in an evening, let alone 45 minutes or whatever. So we are trying to narrow the scope a little bit. Please don't hear that as something that means that anything outside of that is not something that we could address, or something that may have a similar framework or a very different framework, or this is the end all be all comprehensive kind of presentation. So when we talk about sexual harassment in the workplace, what we're talking about is, generally speaking, we're attorneys, so you're going to get a lot of generally speaking, it depends. Oh, that reminds me, there are a few attorneys in here, right? I met 3 other attorneys, and I was thinking, Elaine, next time we do this, we get CLE credit for it also. Yes, right? Am I right? Yeah, so big picture, generally speaking, sexual harassment is a concept that's been around for some time now, probably in the 1970s, and then before that, the Title VII is federal litigation, federal law legislation, and that federal law, Title VII, falls under the Civil Rights Act of 1964. And so we're talking about 1964 gave civil rights, and generally, I think people in people's mind, you think civil rights and you think the whole civil rights movement when we're talking about equality in terms of previous underrepresented, lack of access for mostly African Americans that had been, historical oppression through slavery and everything else. And Title VII comes up in that and it says you can't discriminate against somebody based on, among other things, their race and their national orientation and national background, ethnicity, stuff like that. But it also includes gender. So what that means is sexual harassment, the concept came under that umbrella, all right? So when you can't discriminate against someone because of their gender, that means that if you're a woman, you have the right to work in a workplace that doesn't discriminate against you, doesn't create a hostile work environment such that you are able to go to work and do your job and do it unencumbered, free of harassment so that you can make a living and go about your life. So that's Title VII, how sexual harassment falls under that umbrella. It came back, I don't know how popular it was in terms of a tool for people to prosecute their rights under that legislation. And I became very aware of it, and there was a big turning point, I think, in 1991 when we deal with, many remember, some don't remember, the Anita Hill sexual harassment allegations against our Justice Clarence Thomas during his confirmation hearings. And that brought to light this awareness of, she's going through this, she was testifying at that time, there was all the stuff I think we see now, but in a different scale and in different ways. Non-believing, she's got something out for him, trying to take him down, can't you just take a joke, that kind of thing. And it brought to light, but there were a lot of women at that time that heard her in those confirmation hearings and heard her story and were like, this is happening to all of us in every workplace. This is not an isolated incident. This is not a stretch of my imagination for me to understand and comprehend what that means and how it impacts my ability to just do my job and make my living. So following all of that, I don't know if you've seen, there's a movie called, I think it's called Confirmation, about his confirmation hearings, and it's a fictionalized movie, but at the end of it, it was just so powerful for me because she's like, I didn't even want to get into this. She was basically re-traumatized about the whole thing. She's beaten up in the media all about this, and why did I put myself through it? Because nothing came of it other than she felt like her personal pummeling, right? And they show her at the end, she's reading these letters, just I get chills thinking about it, one after another, from low-wage workers, writing her letters saying, I saw you say these words. It empowered me. It gave me the ability to come out, and I can stick up for myself in the workplace. Thank you for what you've done. And it's stuck with me. So I remember that, and I think of that, and I like to bring that up in these kinds of conversations because we have to remember our history in order to effectively move forward. So after that, there was a kind of a shift in legislation. There was an amendment, I think, to the Civil Rights Act. And it addressed it shifted the way that you're able to, people who believe that they were discriminated against that are successful in litigation can get both compensatory damages and punitive damages. And that punitive damages, so compensatory are it compensates me for my actual losses, and punitive is to punish the bad actor, the bad employer, whatever, all right? So then you fast forward again. So then as a result of that, there were a lot more causes of action brought as a result of this awareness and this dialogue around it, and this is in the 90s. And I was thinking about this talking to my Lyft driver on the way over. She's 32 years old, and she asked me, what are you doing? So I'm going to go down and talk about sexual harassment to a bunch of developers. And I said, it's interesting because I think a lot of young women in tech, well, tech is young, and then there's the women in tech are generally, the developers are coming out of coding school are younger. I feel like this was a big discussion, and it was on the forefront of a lot of people's minds 15, 20 years ago. And then there's this half a generation or a generation, whatever way you call it, and to me it's well, duh, don't we all know about this? And then I talk with young women between the 20 to 32 age range, have no idea what their rights are, and that there are causes of action and there are prohibitions from the federal level down, all kinds of protections against sexual harassment. They're like, well, I didn't know. I didn't even know, what do I do and where do I go? And I think it was just this older generation that just assumed this is all trickling down through mentorship and oral history and tradition. But because there aren't women in tech, doesn't exist. There doesn't exist that. And because in law, it's a very heavily male-dominated profession, similar things. And so I don't know, I found that really fascinating. So I think it's a really great to let's make sure and refresh the discussion and dialogue. And plus there's all of this movement going on that's bringing it to our forefront. So having said all that, that's a little background. That's what we hope to talk about, a little bit about what it is, what do we do if we believe we're on the receiving end of it, if we're in the workplace? What do we do as employers, best practices to, if this comes up in our company? So Surbhi's going to handle that part of it, and I think I'm just going to jump in here and there as we go along.
Yeah. And I do want to say that, we've got a PowerPoint, and so we have some structure to it, but this isn't meant to be formal by any means. So if you've got questions, something sparks something, feel free, shout them out, and we'll answer them to the best of our abilities. Legal disclaimer, we're not giving legal advice. So don't ask me about a specific situation and expect that you'll walk away with a solution. But we're really happy to offer our expertise in any way we can. So to start off with, Neeti had touched on Title VII, and harassment is unlawful, key step. So, Title VII protects, as Neeti mentioned, race, religion, national origin, color, and sex. And there's a lot of protected characteristics that are involved in that. So gender identity, that can fall under prior psychiatric treatment, that can fall under disability, which has its own statute. But as you can see, there's a lot of different protected characteristics, and they've evolved over time. So even though the Civil Rights Act was, 1964, it has changed with the times, and we've started to have new legislation that creates more protected characteristics. There's starting to become some questions as to whether weight can be considered a protected characteristic, employment status, or social class. And so we're going to see more cases come out addressing these issues. And so the law is always changing. So if we're defining harassment, harassment's verbal, visual, or physical conduct that is unwelcome, so that's key, it has to be unwelcome, based on a particular protected characteristic, like the things we just discussed, or is sexual in nature. And it has to impact the conditions of your work, because we're talking about employment-related harassment. And then the last is the legal piece of it. It has to be pervasive or severe. So it's an or standard, one or the other. Pervasive meaning it happens a lot. It's something that you're experiencing regularly, on either every week or every month. Or it has to be very severe, which it means it's something that's really extreme. It's an art, not a science. So the more extreme something is, the less pervasive it has to be. Generally, a single vague comment isn't enough to constitute harassment, except for a few particular instances that we'll touch on in just a little bit. But if you're experiencing something on a regular basis, it's probably harassment if it's unwelcome, it's making you uncomfortable, and it's impacting your ability to do your job.
And it's based on one of those protected characteristics. Yes. Sometimes I get a lot of calls where people will say, there's just this boss and I think he's just a bully, and it's like, okay, well, what is it about you that you think he's targeting you? No, he's a bully to everybody. Okay, is it more women than men? No. Is it more a certain race demographic? No, he's just a bad manager. So that's not a Title VII protected class status. So people sometimes forget, a hostile work environment doesn't mean just a crappy work environment. It means, it could be under other laws, but not under Title VII.
There's actually a court case, and the name's escaping me, but it basically says Title VII doesn't guarantee you a happy place to work. Just one free of discrimination. So, these are, as we were saying, the categories of harassment. Sexual harassment, that's really what we're focusing on today. But race and color, ethnic slurs, offensive or derogatory comments, religion, someone who's ridiculed because of their religious beliefs or lack thereof, because that's also a protected characteristic. You don't have to believe in a certain religion, or any religion. National origin, we're seeing a lot more of that lately. Someone's birthplace, ancestry, we'll get comments. We had recently had a case where, someone on the loudspeaker at a shopping establishment said, Mr. Smith, you need to go back to your country and we're going to build a wall to keep you out. And so things like that, that's definitely discrimination, but it doesn't have to be that blatant. If you feel like someone is targeting you because of that protected characteristic, that's what matters. And as Neeti said, it's not just everybody. It has to be because of that reason. And then there's a separate statute, the Americans with Disabilities Act, that protects employees from discrimination because of a disability. So these are some interesting statistics about who's felt bullied at work. And this is from 2014, so I'm guessing this is probably significantly underreported.
So as we're looking at this slide, when we look at who's feeling bullied at work, right? Workers with physical disabilities, LGBT workers, African Americans, Hispanic, male and female. There are, and because we're talking about sexual harassment in particular, I'm going to not dwell on especially I think the uptick in race-based and religion-based harassment in the workplace, but as it applies to sexual harassment and gender-based, right? Gender-based. I mean, this is a room full of women for the most part, but it can certainly, men are victims of sexual harassment as well. When we look at these numbers and who has felt bullied at work, who is on the receiving end of this, these are reported cases. And when we think about this, we're hearing a lot about this Me Too movement, especially when you look at celebrities who are coming out talking about this. These are people who actually do have power in their industry. We're talking about Salma Hayek, we're talking about Ashley Judd, pretty big name people, right? And so when you listen to their stories and how they say, I didn't feel like I could have come out and said something because, and it's always because of the imbalance of power, all right? The power inequity that occurs in an employment or business relationship, right? So when you look at these numbers and you think about who is not reporting these cases, think about the other end of that spectrum, the lowest and low wage earner. When there's an income inequity along with that feeds into the power inequity. When you're talking about people who are working minimum wage jobs, multiple minimum wage jobs, they can't afford to risk losing their job. They're more fungible in terms of getting somebody else to fill that, doesn't want to make waves. So these are people that are not necessarily going to report. When you're talking about immigrants, that they want to lay low under the radar, I don't want to be targeted for anything else, let alone undocumented immigrants, right? Then you're talking about also anybody in the service industry, hotel workers, maids. There's a whole slew of cases and examples out there, which is horrifying. I didn't realize it just of people that take advantage of maids and the maid service in hotels. The sexual harassment, sexual assaults that happen, and literally they say, nobody hears you if you scream. You're in a room alone. I mean, some hotels are installing panic buttons for their staff in hotel rooms. So if you're cleaning a room, there's a panic button. I mean, that's crazy. Like, we need a panic button in a hotel room instead of, upstream avoiding and training and ensuring that we're not going to have protections in place. So, and then you look at people who work in the service industry, people who work for tips. Right? If the federal minimum wage is a couple bucks, I don't know what it is specifically, 2 something an hour, and your entire living depends on putting up with something so that you get a tip, that just feeds into that. So I mean, these are again income inequities and power inequities that feed into a lot of that harassment. And when people at that level are harassed in high numbers, I think it trickles up, right? I don't think it trickles down. I think it goes both ways. So this is a slide that I think it's a good starting point, but it gets you thinking really how probably pervasive and underrepresented this is.
So if we talk about some key facts about harassment, these are kind of important things to remember. What the harassing act is doesn't have to be the same thing every time. So just because someone calls you one word today, then tomorrow they push you, and then the next day, they put something on your desk, that's still harassment, even though they're not doing the same act repeatedly. It's still a pervasive form of harassment because they're targeting you because of your gender or because of your race. And so that's an important thing to remember, because a lot of times people will feel like, well, he asked me out, I turned him down. The next day he, bumped into me in the hallway. The next day he brought me flowers, or he sent me an email. But he wasn't like, it's not that he kept asking me out every day. But that's still sexual harassment, because he's targeting you because of your gender. And it doesn't have to be the same thing every time. It's also not necessary for the person who feels harassed to vocalize that the conduct is unwelcome. If the person, you ask someone out and they say, no, I'm busy, but they don't say, okay, I want you to stop asking me out. The third time you've asked them out and they've said, no, I'm busy, take the hint. Like, they're not interested. They don't have to say, I feel like you're harassing me, you need to back off. It's unwelcome. And so that's the importance between recognizing that line. what's offensive in the eyes of the beholder. So it's offensive to me, but it's not a completely subjective standard. It has to be in the eyes of a reasonable person as well, right? So if you get asked out once, probably not harassment. Twice, maybe still not. Now, if it's happening regularly, 3 times, 4 times, it's happening every day, every week, is a reasonable person going to think that's harassing behavior? Probably. If it's someone you work directly with and have to see every day, probably. If it's a supervisor, even more likely. So you have to look from a reasonable person's perspective. And then the harassment doesn't have to be directed at an individual. So just because 2 male colleagues are, looking at the latest leaked photo of, an undressed model, and a woman walks by and feels uncomfortable in that situation, even though they weren't showing it to her, that's still harassment because she feels uncomfortable in the workplace. Again, if it happens once and she asks them to stop, or she reports it and someone else asks, maybe not. But if it's happening regularly, or if there's a pinup on someone's cubicle that you have to pass by every day, that's harassment. And it creates this feeling of women are not respected in this environment. And that's what's important to distinguish that. Do you feel respected? And is it that someone is targeting you or is creating an environment where women feel like they are not welcome? That can lead to a hostile work environment. So harassment begins with unwelcome or unwanted conduct. Sorry, that says wanted conduct, unwanted. I just noticed that. So, unwelcome or unwanted conduct. It's what is perceived, and it's not limited just to sex. So it doesn't just have to be in a sexual nature, like we talked about. It can be someone, thinking, oh, well, you're just a female, you don't know how to code, or you don't know how to handle this. Here, I'll do that project. You can handle the easier project. And so if that's repeated and it makes you feel uncomfortable and it's targeting you because of your gender, it doesn't have to be sexual. It's still harassment based on gender. So there's 2 types of sexual harassment: quid pro quo and a hostile environment. So you've kind of heard me touch on the hostile environment, but we'll delve a little bit deeper into them. Quid pro quo, we used to see a lot more of, 20 years ago, I'd say. It would be, sleep with me and you'll get promoted. So a lot more of the favor in exchange. While it's not as prevalent, it's still out there. It can be more subtle. Oh, well, if you go, let's discuss this project over dinner. Well, okay, now is that a working dinner or is it a date? Is it someone who's already asked you out multiple times and you've declined and now you feel like you have to go out with him or you have to go to this dinner with him in order to get this project that you really want? So that is kind of the more murky situation that we are coming across. It's much less blatant now. Hostile work environment, this is where we're seeing a lot more of the cases. So this is where it's based, again, on a protected characteristic and is sexual in nature, or is sexual, I'm sorry, and is unwelcome. So it impacts the conditions of your work. So you can see that it creates just an uncomfortable place for you to be. And that's really what you want to pick up on. If you're feeling uncomfortable, why are you feeling uncomfortable? What is it that's leading to that feeling of discomfort in your workplace? If it's just you've got a really hard manager who tends to micromanage everything and he does it equally to males and females, okay, that's just a difficult work situation. But if it's because of your gender, it's because of your age, then that's something to think about.
Before we go off from that, move on from that slide, you don't need to go back. At the bottom, she gave some examples of, it can be gender-based harassment, it can be same-sex harassment. So I was saying earlier, it's not always, I think there's a traditional sense that, it's when a man is harassing a woman, a man is putting his hands on a woman, something like that. It can go the other direction. It can also be a manager who's a woman and has, male subordinates and doing inappropriate stuff or same kind of stuff, jokes, harassment, innuendos, what you can do, physical characteristics, so it can go that direction. What I think is really interesting is where we're going moving forward. When we're talking about gender fluidity and gender identity, transgender individuals, when we're talking about that kind of dynamic and where I think a lot of us have evolved in terms of our workplaces and recognition and interactions in communities, it is, you know, back to the 20 years ago, I think we were talking about this and it was very aware. Well, 20 years ago, those people that were like, I'm all on top of this, I understand, are the ones in charge now. And they're still thinking of it in a very binary way. And so they're very unaware of like, well, what do I do? And what about the bathrooms? And you know, that kind of thing. And a lot of it is their response is stick your head in the sand. Or I learned about this, so I'm not one of the bad guys. I already know, you know, how to prevent this. And there's a lack of understanding of how gender identity and gender fluidity and all those interactions have evolved over the past couple of decades. And so we're seeing a lot of that now coming up and bubbling up in our practices as well.
Yeah. And going along with that, you know, anyone can commit harassment. It can be male or female, supervisors, managers, but coworkers also. And then the important thing, I think, especially in this industry, is that independent contractors can also feel harassed and they can also be the harassers. Clients, visitors, vendors, all of those people. So generally, you know, if you are an independent contractor and you're feeling harassed, then you are still protected by Title VII. Now, what your place of employment is, that's up to, you know, it depends if you work for a company, if you're truly independent and it's just you solo, then there's some room, but you are still protected from sexual harassment in that workplace because they have hired you and brought you in.
So along that, like I think it's really interesting when you talk about vendors, especially in our gig economy and our freelance economy, right? So a lot of us, and I'm self-employed, and if somebody, as an independent contractor, you're doing work for a company and you go in and you're harassed, you don't think, you might not necessarily think, well, I don't work for the company, so the company doesn't have an obligation to provide me with a harassment-free environment. They absolutely do. There is it's unequivocal that an employer does through Title VII and through our state protections, which is the Colorado Anti-Discrimination Act, CADA. And those are, it's really strong actually in Colorado, I think more strong than at the federal level. I'm totally looking to Surbhi for like, right? That's right, right? She's the smart one. And the pretty one. So yes, you have protections as an independent contractor, as a vendor who's going in, and again, a lot of us are freelancers and you know that happens. On the flip side of that, all the employers in the room, you think, okay, all of my employees are going to be independent contractors. I don't need to worry about having a harassment policy that vendors need to be aware of and sign off on and be handed when they sign off on a contract. They do need to be aware of that. So, you know, it goes both ways.
So unwelcome conduct can be visual, verbal, or physical. We're going to go through some examples here, and again, my legal disclaimer, please don't be offended by anything we show you. Again, it's meant to be an example of what you may see and what's inappropriate. Do not do any of these things. So we've got visual harassment. This is, you know, like we said, displaying centerfolds, sexual screensavers, any kind of images, even on your phone, if other people can see that, you know, your when your phone's locked in that screen. Yeah, you tech people know what I'm talking about. Calendars that you have up in your cubicle or in your office, you know, sexual objects, belittling photographs, cartoons. Sometimes people think, oh, if it's a cartoon, you know, that doesn't really count. It still counts. If it's sexually explicit or if it's inappropriate, think about what would you want your mother to see. That's what should be in your workplace. Suggestive or demeaning pictures, cartoons, emails. This is a no. Do not wear this to work. Don't send it around in an email. This is just not appropriate. This one. So, funny, right? But twerking is inherently sexual. Probably not a good idea to send this around at work, even though it is funny. And males can feel sexually harassed just as much as females can. So, just something to think about. Also kind of funny. But as Neeti was touching on earlier, this leads to the issues of transsexual dressing. So, while you might think, oh, no one's going to get offended by this, it's hilarious. Well, someone who might feel uncomfortable with, how they choose to dress themselves or are not ready to discuss that may feel harassed. So something to also think about. Then we've got verbal harassments, telling sexual jokes or stories. You don't know who's going to hear you as you're telling what happened on your date last night. And it may make someone uncomfortable as they walk by. Commenting on physical attributes or the way clothing fits. We always say better to comment on someone's intellectual abilities if you want to give them a compliment. The whistling or catcalls, we tend to see that less. This is something that I think may happen more in your industry, referring to someone as girl, doll, babe, honey, regardless of age. I know I get it in the legal profession, and sometimes they're just trying to be polite. You pick up the phone and they're like, how are you doing? Or you're such a sweet girl. And yes, but I'm also your attorney and I am representing you, and so let's talk about that. But you don't want that. It demeans who you are professionally. And so, if you're comfortable enough, you can say, my name is Mrs. Smith. And we can go from there. But it can make you feel inferior, and that's the point of sexual harassment. It's a power structure again. Again, we talked about requesting a date, expressing negative stereotypes. Oh, you're a blonde, you can't understand this. This is above your pay grade. Things like that. And of course, sexually explicit language. That's definitely verbal harassment. So then we've got the word grenades. Things like the C word. It's considered by many to be the most offensive word in the English language. That's according to Urban Dictionary. But and then there's some examples that I won't say out loud, but at the bottom where they've been cited by the 10th Circuit, which is the federal circuit that Colorado falls under. Point is, there's no excuse. There's no reason for such language in the workplace, and the courts have zero tolerance for it. So this is what we were talking about when something is extreme enough, severe enough. This is just once. Once equals harassment. You call someone one of those words, and then if they file a sexual harassment lawsuit, chances are they were harassed. An employee needs to be disciplined. Now, as we talk about, there's a difference between what is harassment and then what the employer's responsibility is. If it's brought to your attention that one of your employees called someone word grenade, as we like to call them, they need to be disciplined. There's no getting around.
So I want to talk about this. I mean, this is probably a bigger discussion. So our president, has been saying these words on a nonstop basis. Don't you think that every single woman that is working in the White House would be in a hostile work environment? I mean,
If you were to ask my opinion, I'd say yes. I would think that that is the environment they're working in. Now, what they can do about it, that's, they could file harassment claims and go forward from there. But
would it be against the federal government? I mean, who would you file a lawsuit against? The White House itself?
Yeah, I mean, there's got to be immunity issues involved in that, but you could probably, I'm guessing, so. Yeah, you would go to the EEOC and file your complaint, and somebody would investigate, and I'm sure those people would probably be, promptly removed from their positions of, employment, and then they'd have retaliation claims, and it would just be a whole, spiraling nightmare.
I didn't really think about that until you just, these are words that this person uses.
Yeah, and it's an interesting issue because we are seeing more cases with word grenades. I think because it's become all of a sudden more socially acceptable, or you're hearing them more. It's becoming normalized. Thank you. That's the word I was looking for. And so, but at least as long as these court cases are standing, they're not normal. And so we want to prevent them from becoming normalized. And we, as much as we can do to create an environment where this is not tolerated, especially in the workplaces we're all at, then that's really important. And even though we're not specifically talking about race discrimination, the N-word is also considered a word grenade. And then we don't have specific court cases that have addressed it, but it's likely that words like dyke or fag would also be considered word grenades. So you want to just be aware, anything that's so charged and has such hatred behind it is really what falls under a word grenade and shouldn't be used in the workplace. And then we've got physical harassment. So this is, the unnecessary physical touching, patting, pinching, brushing against another's body or hair, standing or sitting too close. The elevator eyes, everyone know what I'm talking about? When you look at someone, I'm gonna use this lovely pole and you go So you stop at each of the important floors and then you do a once over. Yeah, that's not good. Don't do that. And it's funny because those are actually more of the cases where I've heard that males feel that they've been sexually harassed by the elevator eyes. So, and then, touching is obvious, but physical intimidation is also a form of physical harassment. So, when someone's a lot bigger than you and they're standing up really close to you or where you feel like you can't move and they're taking up all the space around you, that can make you feel small and harassed. And if it's happening regularly, especially if the person's behaving in an aggressive manner, that's a form of sexual harassment.
As a best practices, we see it in our profession. If this was a chair like behind a desk, let me dictate to you, and the hands go on the shoulder kind of a thing. And it's the most awful, it's the most innocuous touching, seemingly innocuous, but it's actually the one that's like conveying all of those elements of that power structure imbalance, that lack of voice, that physical I can't get up from my workspace, and it's guised under this I'm just your boss and I'm mentoring you and I'm guiding you and I'm helping you, edit this document so that we will be successful and it's all for the client and that kind of a thing. And again, we've all been there. So I think that goes on the list and it's kind of a good example of why am I? It's all the checks, right? So.
Then we have the that blue's a little hard to read, but can consensual relationships lead to sexual harassment? And it can. It's especially when there's that power imbalance. You see it less with coworkers that are in a consensual relationship, but if one of them gets promoted, all of a sudden they're assigning the work. Can that lead to sexual harassment? Especially if the relationship ends. What does that mean? That can lead to sexual harassment. And also what was once consensual doesn't mean it's always consensual, as we're kind of learning, right? And so even though a person agreed to go out with you and then broke up with you, if you keep asking them out repeatedly, now that can be sexual harassment, even though at one point they'd agreed to date you. And so you have to be aware of the power structure. And it's generally, a lot of the bigger employers have policies on requiring disclosure. And you want to just loop in someone that this is happening, especially if there is a case where someone gets promoted or becomes a supervisor. It's generally best to let HR know that we were in a romantic relationship. It's consensual. They'll probably have both employees sign some forms and so forth. But and I'm not going to say you can't date in the workplace because that's just it happens. It happens in every workplace. But just be aware that can be the source of sexual harassment. So, talk a little bit about some excuses that won't work. If you have been accused of sexual harassment, saying things like, everyone was laughing at the joke, that won't help. She didn't object to the comment when it was made. Remember, the victim has no obligation to tell you that it was unwelcome. I didn't mean to harass anyone when I said that. Well, yeah, I will say, generally most people do not set out with the intention of harassing someone. They're saying it because they think it's acceptable, but they don't think about the consequences or how it makes the other person feel. And the point is that it's how the person who was on the receiving end of it felt. So if they felt harassed, it was probably a harassing comment. We get this sometimes from employers. We have an environment where people just say what they think. She just needs to get used to it. Well, and we see it a lot in, sometimes in mining companies or in construction companies where, well, this is just what we do. The guys are joking around, like, she wants to work here. No, that's not how it works. It's the employer's job to create an environment that's safe and comfortable for all their employees, and where that no one feels harassed or discriminated
That
against.
feels just like a per se admission of liability to me from an employer.
Yeah, usually they're saying it to their attorney, where we're saying, no, do not repeat that.
Well, it's like Surbhi's answer to that is get your checkbook out. We're just going to have to write a check.
And we're not doing that again. And then I can't do anything to change the way people speak or act. Yeah, you can. You can have policies, you can have discipline, you can show that this kind of behavior is unacceptable in your workplace. And so that's, it's very easy to throw up your hands and say you don't have control or it's not in your power, but it is. And then the very last thing we'll touch on, sorry.
I feel like I heard somewhere, or remember learning that it's not how it was intended, it's how it was perceived. Is that sort of what the slide is? Is that true?
Yeah.
And is that what that slide sort of gets at?
Yes, it is how it was perceived with the added piece of the reasonable person standard. So would a reasonable person have perceived that as harassing behavior? Now, what it takes for someone to feel harassed and to file a claim is very different than what it takes to win a lawsuit. So if I feel harassed by your conduct, I'm more than welcome to file a charge with the EEOC. Now, what going forward from there is if a reasonable person would have found that to be harassment is what the legal standard is. But it's always what does the other person feel, not what you were thinking when you said those things.
So along these lines of excuses, and I think this is segueing into your next slide, we talk about what can we do about it? I can't change the way that people act or think. We just have an environment this is just not my problem. So after, let's see, I would say the late 90s, okay, there was a couple of cases that came out of the Colorado Supreme Court. One of them is Ellerth, and one of them is Farragher. And these two changed kind of the framework of how we deal with sexual harassment cases and liability that's attributable to the employer. So people who are employers, perk your ears up. It used to be that, gee, I can't know what any of my employees are doing. That's between them, all right? So, and in Farragher specifically, it was against a city, and the city's like, well, we're not even, part of every agency and that kind of a thing, so you can't hold us, the employer, responsible for the individual acts of our individual employees and managers and that kind of thing. So these cases went all the way to the Supreme Court, and the Supreme Court said, no, you have a responsibility, employer, whether you're a governmental agency, whether you're a private employer, to provide a workplace free of harassment. And so if you get notice, and notice to the employer is somebody reports it to HR, somebody reports it to any manager, anybody who has some sort of authority, decision-making authority within, and it doesn't have to be the direct manager. If my direct manager is harassing me, I can go to any other manager to HR. Even if I don't report it, if another manager sees the harassment, that is notice to the company. So now the entire company is on notice and can't say, I didn't know, all right? That's notice. So notice triggers responsibilities, and it requires duty, it triggers duties. Those duties are you have to investigate, find out the factual, whether there's a factual basis to find any policy violations. I'm going to touch on that too. When I say policy violations, emphasis on policy violations, I'll tell you why in a second. And secondly, if there is, to take prompt remedial action so that to address the conduct and ensure that it won't occur again. All right, so that's a big spectrum. So when you're talking about some of the stuff that's, the awful T-shirt or the brushing up or the one thing, let's assume it's a conduct that's not horrific, right? The obvious, egregious ones where you're like, that is one thing that creates a hostile work environment. It's probably also assault if it's that egregious. Set that aside for a second. When you're talking about, oh, gee, I didn't know, or they just misunderstood me, or that kind of thing, or it's the first time that I ever, kind of crossed the line, that kind of a thing. So then the employer has a duty to investigate. And investigation means you look into it. You don't just say, well, tell me what happened. Nah, you're overreacting. You conduct an investigation. What happened? How did you feel? The who, what, where, when, how, and why. And then who saw it? How did it make the recipient of the conduct or words feel? And you do make sure that the alleged bad actor has their say also. What did you do? What did you say? Blah, blah, blah. I didn't mean it. Okay, fine. Maybe you didn't, but you understand it's not, the meaning versus the way it was received. And then, so when that investigation happens and you take prompt remedial action, you can say, look, yes, it was harassment, it was policy violation, but it wasn't so egregious that it just triggers termination. There's a whole spectrum in there. So is it slap on the wrist, tell them to say sorry, I'll never do it again? Is it send them to diversity training or sensitivity training? Is it have them attend, I love this one, have them attend a gender equity kind of a class seminar, that kind of a stuff? Or is it suspension, suspended without pay? Is it transferred to a different office? Where you say, we're going to address these situations, we're going to deal with them accordingly, and we're going to make sure that people feel empowered to come to HR and that kind of thing. Now, it's a double-edged coin, right? Because employees feel like, again, there's a spectrum. You've got assault on one end, right, where not only would you might want to tell HR, like, this happened, this is a harassing environment because my manager physically assaulted me, right, did something so egregious that not only is it harassment, but it's assault. Then you have to talk about, like, do I need to call the police and what needs to do to, like, for my safety. So that's on one end. And then you've got it's harassment. Maybe it's a policy violation. Maybe you're using your position of authority as my manager or something to make me stay late hours because then I have time alone with you so I can make innuendos and try to hit on you because we're trying to get the slide deck done or whatever it is. That's assault, harassment. And then you've got inappropriate. Inappropriate, that's I think where a lot of people like to dwell when they say, yeah, but, I can't do anything to change the way people speak or the environment. You can if you create an intolerance around the other two. And you say, look, yeah, maybe it's not a policy violation, but it's inappropriate. But if the inappropriateness ends up being gender-based or any protected class-based, and it's pervasive enough, it can get promoted to harassment, a policy violation. So there is a responsibility and incumbent upon the employer. Do you want to jump in or want me to keep going?
No, keep going.
All right, so part of those investigations, the question is, can I talk about investigation? Is the employer has a duty to investigate, and a lot of times historically that has meant, right after those cases came out, to say, well, we have our HR person and they went and talked to each of them and they just kind of did a 2-line thing and put a note in the file. That is not the best practices. HR people have their own jobs. They're often swimming, drowning in a lot of other responsibilities, everything from payroll to writing job descriptions to dealing with everything else that goes along with that. The HR person also has working relationships with everybody else involved in the company, right? So even if they are able to say, look, I isolate myself, I shut my door, I don't know what's going on out there, I keep myself out of drama, there's a perception of bias, right? Like, oh, because she always goes to lunch, the HR person always goes to lunch with that person or that manager. Or that manager is also the person who does the HR person's performance review. So there's an appearance of bias sometimes, and even if it's not, people can read into that. So a best practice is have somebody from the outside, have an independent person come in and say, all right, I don't know any of the players here, and conduct an investigation. In that investigation then, you don't just do an investigation and stick it in the file. I mean, employers do that all the time, yes, absolutely. That's not best practices. Best practices is do something about it. And the reason is because the lawsuit will inevitably happen, right? You will inevitably, if you're an employer, need to hire somebody like Surbhi eventually, and not because you've done anything right or wrong or whatever, it will happen. So the more times you have done something and taken things seriously and imposed commensurate discipline or not when it's not founded, and you have different kind of tiers and levels of discipline along the way that shows that you are engaged in that process, understanding where your employees are coming from. Then when the lawsuit comes down, you're like, yes, we have a history of this. Yes, we do the right thing. It limits your liability then, right? Because you're not required to write a check for everybody who's a bad actor. You have to write a check as an employer when you know about it and don't do anything about it. I mean, you do have to write a check when it's a bad actor also sometimes, but you're not held to the same, like, gee, I didn't know. If there's a whole history of the physical touching offenses and nothing's been done about it, and you're like, clearly we cannot have this person around this protected class of people because it's a perpetual problem, then it doesn't matter how much you pay per file, you're going to have liability. On the employee side, what do I do, right? Do you want me to jump into that, or you want to?
Yeah, I mean, I think we can kind of, so sorry, these were just some more excuses. But yeah, I think this is kind of what to do if an employee approaches you. So let me touch on this and then we'll jump to the employee side. So you want to, if you're a supervisor, if you're a manager, you want to make sure the employee feels comfortable. They're coming to you with something that they feel is traumatic or that they are already feeling vulnerable and having to discuss. So you want them to make sure they know that you're taking their complaint seriously, but be impartial. Don't, oh yeah, that guy's always the worst, or yeah, she's a total pain in the ass. Like, you don't want to validate anything and you don't want to show any bias. Be impartial. I'm sorry that happened to you. Tell me more. Why? And you want to get as many details as you can. Don't object if the employee bypasses the chain of command, kind of like Neeti was touching on. They don't have to go to their supervisor. They can go to some other supervisor. They can go to HR. There's no strict, they may just not feel comfortable discussing this with you, knowing that they're going to be reporting to you again tomorrow. So there's no right or wrong person to go and report sexual harassment to. Know the company policy, have employees review the company policy. We generally suggest having a separate signature page for having reviewed the discrimination policy, just so that employees know what the official reporting structure is. And then, only indicate confidential to the extent possible. You can't guarantee an employee that what they're telling you is going to be confidential. Even if they tell you, I don't want you to do anything with this, I just feel like you should know, you still have an obligation to do something with it, because they have now reported to the company that they felt harassed or that they felt that some behavior was inappropriate. So it does need to, if it needs to go up your chain of command, if it needs to be reported to HR, whatever your internal reporting structure is, but you want to do something with it. It isn't just, okay, she told me this, but wanted me to move on from it. And then you want to ensure there's no retaliation. So just because someone reported something to you, make sure they're not taking off any projects, make sure they're not had their offices switched when they didn't want them switched, and then respond to the employee's complaint. We're looking into this, we are going to investigate. Those are kind of the message you want to make sure the employee is getting. Also let her know or him know that you're not obligated to tell them what the outcome of the investigation was. A lot of the times you may investigate and find that this really wasn't harassment. This manager was just mean to everybody, or whatever the situation was. And you're not obligated to tell them that, but you should tell them that you're investigating and you're going to take appropriate action, and but it's not going to become public knowledge. So even if the manager is disciplined, maybe it's not something that's severe enough that everyone's going to know about it. He had to attend a training class. You don't want him to feel like, oh, now everyone thinks I'm a harasser and have his own issues. So a lot of this stuff is treated sorry, a lot of it's private. And so that's just something to keep in mind. Sorry, I'm trying to speed up because I know we're running a little long. So Neeti's going to touch on from the employee side. So this is just a summary of kind of what I talked about in the previous slide.
All right, so if I'm the employee, what do I do? So now I'm taking my neutral hat and I'm playing, like advocate for the employee side. HR is there to protect the interests of the company, all right? HR is not there to provide individual protections for each employee. They have an obligation to provide a harassment-free workplace, and in theory, if you wanted to talk about this in a best light possible, the employer is there to protect the corporation, and the corporation is protected by ensuring you have a harassment-free environment. So in theory, those things should dovetail together and everybody should be happy, all right? But that's not often how it happens. So you're an employee, you've been the victim of harassment, physical, verbal, or visual. And it's either been one horrible act or it has been pervasive. It's severe and pervasive, or pervasive. So at that point, the question becomes, what do I do, all right? And the answer to that, the lawyer disclaimer, is a whole big fat, it depends, right? If you think you have been physically assaulted and your safety is at issue, you make yourself safe. You leave, you call whoever you trust, you call the police, you know, do whatever you need to do. You don't have to stick around and be like, oh gee, but I don't have PTO time and I've just, you know, been like physically assaulted in the bathroom or something. You have to take care of yourself. And then you can call, you know, when you make your police report, or you call your best friend, and your best friend helps you contact HR and say, I'm not coming back to work, here's why, I'll give you more information, that kind of thing, all right? So that's on one extreme. If you've been harassed and still it's a touching or it's uncomfortable or something that was very severe, but not where you felt like, oh, I need to involve the police, what you do is you get your wits about you, you jot your own notes down first. All right, you make sure that you have in your mind a recollection of what just happened. Because as time goes on and you tell your story and other people have their input, all of our minds, our memories fade anyway. And then the integrity of your recollection with time, with influence by telling your story to other people hearing the story, changing the who knows what, that kind of thing. So you get your wits about you, you jot some notes down about what happened, what specifically was said, who was there, what they observed, you know, all the details about that, like that you can get. Try to get whoever was also in the room or in the area that might have observed, heard, you know, whatever it was, to also jot some notes down, contemporaneous with when it happens, again, because you want to preserve the integrity of recollection. Then you go to HR, unless HR is something that I was part of the problem, or my manager was part of the problem. You go to whoever it is that you are going to report this to, because again, management, notice to anybody in management is notice to the company. When you do that, be prepared to have a conversation about what it is that you want to have happen in the meantime, and then what it is you want to have happen as a consequence, right? So in the meantime, I am not safe right now. I understand I would like, this happened to me. I believe it violates policy. Oh, that's the other thing you should do. When you get your wits about you and you take your notes and you do all that, also refer to your own employment or employee handbook or employer company policy procedure manual. There should be by now, it's scary to think that some people still don't have these, but there should be by now, all employers have a policy on reporting harassment. So follow the policy. All right, and if there's any glitch in the policy where I can't do this, I can't do that, do the best you can and have like an understanding or reason why you couldn't comply with certain parts of it, because it may be that those parts are non-material. So when you make your reporting, say this happened to me, I reviewed the manual, I'm reporting pursuant to this policy, reporting policy, and I'm telling you all the who, what, where, when, how, and who else was there and saw it and all that kind of thing. Also say, so I would like an investigation to occur. In the meantime, I don't feel comfortable coming to the workplace where this person works with me, the one that's hanging over my shoulders and looking down my shirt or making lewd comments while they're dictating a letter to me, or you know, whatever it is, massaging my shoulders after I tell them 15 times to stop. So you know, I want an investigation. I don't feel comfortable doing that. Maybe in that case, I don't mind if I'm in the same place, but I don't want to be the person that's the paralegal for that attorney anymore. Assign me to a different attorney. Or it was that pervasive, I can't be in the same space. So make them go on administrative leave, be at home, whatever. Or, you know, I need to leave and do work in my Houston office anyway. I'll go and work there and while this is being played out. So have an idea of what you want to have happen while this gets resolved. And usually it shouldn't take more than, it can be a couple of days, it can be a couple hours, it can be a couple of days, it can be a couple of weeks. I was involved, or I was the investigator on one where it ended up just triggering this massive audit of the entire office. It's a national corporation, the whole Denver office. I interviewed in excess of 50 people, and it took me a month. So there was nobody put on administrative leave in the meantime, but it was a nightmare. Yes?
So I work with startups, and a lot of startups don't have policies in place, nor do they have HR.
Yes.
And then sometimes the founder is the issue and/or investor. So that's like a company I worked at, and I have former teammates are still there dealing with these issues. They don't have anyone to go to. What happens then?
They go straight to EEOC.
Okay. And then, but they just expect that their job, they can get fired, or how does that work? Or like.
Well, could they? Sure. Yeah. There are non-retaliation, laws in place. So again, it doesn't mean it's not. There are non-harassment laws in place. People harass every day. There are non-retaliation clauses and things in place. People violate those. So it's a matter of just having your ducks set up in a row, because if all the wheels fall off the bus and you're just left with, I have to file a lawsuit, now you've got your documentation in order, you've got requests in order, I've asked them to do all these things in proper procedure. I continue to work there in this harassing environment, my damages are going up every day, that kind of a thing. And so then you file with the EEOC, and they will do an investigation and that kind of, yes.
Yeah, you need to make sure, though, that it's not a he said, she said kind of thing, or she said kind of thing, because it could be that, or he said kind of thing, right? So if you have some sort of, I used to be a prosecutor, so you have some sort of additional evidence.
Oh, we have lots.
Oh, okay.
We have several people, and women do not work at this company anymore.
Okay, well, that's
So,
fine. I
yeah.
just wanted to
Yeah.
make sure that.
Right.
you know.
So when when the investigation's being done, that's the kind of things that they will look for. So again, is there a pattern? Are there other indicators? It's not always verbal. Sometimes, the indicators are other contextual things. So what to do when you file a report, you go to HR, you have your thing, and then when they can conclude their investigation, they may or may not tell you what the outcome is, and then you have a specific, here's what I would like to have happen if the investigation comes back as a policy violation. I would like them, no, I'm not horribly damaged, I just want it to stop, so I want an apology letter. I want training to be offered to everybody. I want just this person to go to training. I want there to be, like we said earlier, some sort of like race relations, gender equity, whatever it is, kind of
But as an
symposium.
employer, they're not obligated to
Correct.
give the whatever you request. I think it's a great practice to have something in mind if there's something that you think would make you feel whole. But the employer, they may just decide, no, we are not going to suspend this person. We don't think it was severe enough. That's based on their investigation. I think, sorry.
Yes,
you had a
sorry, I
question?
just wondered about that part of it.
So I feel like I've done this process pretty much all the way through with my last company, where it started with one individual, and then it became my boss, who was also the problem, reported it to HR, who defended the boss and told me I had a personal problem I should fix, and then went to the EEOC. And the thing I ran into is, like, a lot of times when it's less of a accidental, oh, I didn't mean to make you feel bad thing, and more of a pervasive, like, no, I want you to sleep with me kind of thing. I don't know how I could have gotten like hard proof, and I think like I got to the EEOC and started that process and then chickened out because I thought, like, what, I'm gonna stand in court and say like, okay, yeah, he asked me into his office and he was like super creepy, but I don't have a photo of it. It's not like I whipped out my cell phone and took a video of him being a creep, so I don't, like, how does that stand up?
It's a really good question. So the next step is, you don't like the outcome of what they did. So what are my remedies? So then you file with the EEOC, right? And I think EEOC is getting more progressive in terms of its willingness to understand that there isn't always this, a big like red flag. Yeah, there's not the smoking gun or whatever you want to call it. And so there is more of a context. Part of depending on where you are in that continuum and when you're reporting it, hiring a lawyer. Because again, people will go to HR thinking HR is there, they're going to protect me. They're there to protect the company. And again, the company is protected by making sure they follow their policies, but that's not protecting you and making sure you're going to be made whole necessarily. There is a responsibility on the employer to do that, but I think they're looking at it more from the lens of how do we limit liability. So, often it's get a lawyer to help you draft that complaint, the request of what I want to have happen. Definitely by the time you're going to EEOC, drafting that with an attorney is going to be beneficial to you because they'll know how to frame that up better. But ultimately, how do you get a win? Like is it Karen, is that right? Yeah, what she was saying is ultimately to get a win in court, a lawsuit in court is a whole nother animal. And you're right, there's, and Heather is going to speak about this, when you are weighing the cost benefits of pursuing something, a legal action in court, it is time, it is years of time. And those years of litigation time take years, like dog years off your life. And how do I move forward? You're living in limbo, you have stagnancy and uncertainty for a long time. I'm not saying you shouldn't do it, but you really need to be aware of what it is. And having an attorney explain that to you before you just say, I'm so pissed, I'm gonna go do this. Also, the cost of it. So you have to pay for the costs, even if you find an attorney to handle a contingency, meaning they only get paid if you get paid. That's attorney's fees, but costs are depositions, transcripts, travel, filing fees, and it racks up. It can be $10,000 in costs over the span of a couple of years of litigation. And then it's what's the emotional toll on me, and what am I going to get out of it? My chances of victory depend on, is it a he said, she said? Do I have any proof? It's one creepy thing. who knows? It's totally subjective. Maybe it was creepy, maybe it wasn't. So those are significant factors to weigh.
One thing to keep in mind, though, is a lot of the times, don't give up at the EEOC phase. At least let them finish their investigation, because you're not obligated to file a lawsuit. And I generally am defending the companies, but I will say, if it happened to you, it probably happened to someone else, and the EEOC will try. They're not always successful, but they'll try and find out if that's a pattern or if it's happened to someone else. And so it's something to keep in mind, that at least through the EEOC phase, except for the emotional toll it's taking on you, there's no other costs. And generally, once you've made your complaint to the EEOC, there's little involvement from you unless you want to be more involved. So kind of let them go through their process and see if they find anything.
So if you file a complaint, is that then registered so that if someone, let's say you file a complaint with the EEOC and then nothing happens, there's no lawsuit, but then 2 years later another employee comes forward and says, hey, this happened to me. Can they look at your complaint, or does it have to be a lawsuit in order to sort of be seen as repeat behavior?
It can be seen as, if you have filed, it's the same bad actor.
Yes.
Well, then in that employee's file, there should be, it's not even the EEOC, it's just the internal going to HR and having them do an investigation or not, or whatever.
What if you're someone who's founder,
Right.
for example, is the perpetrator, so you went directly to the EEOC and there's
Yeah.
no,
I mean, the way that happens is by employees knowing. I'm sure that you find your other plaintiffs, you find other people who have left under similar circumstances, and so the answer is it depends.
And it depends on the EEOC. So I won't say the EEOC keeps a file on every employer, and if there's now if you happen to get the same investigator or it's a story that was passed around, they may discover it. But I don't think there's any guarantee that just because someone else filed a complaint with the EEOC, that the next person who files a complaint that somehow that complaint will be factored into it. I've never worked for the EEOC, so I don't know exactly how their internal process works, but as far as I know, there's no, keeping track of every complaint that's filed. Now, if it's within a short time span, I'm sure it's there. But if it's, 10 years ago, I don't know. So I'm sorry, I know we'll have time for more.
Yeah, we have far exceeded our
Yes, I'm so sorry.
So.
I want to ask Neeti a question because when we talked, I thought it was important, so correct me if I'm wrong. HR, we discussed, is, and you said, on the side, they're there to protect the employee. And
Employer.
The employer. And then a good HR person will put all these policies into place. But it sounds to me like after you've gathered your thoughts, you've jotted down your notes, you should potentially go and call a lawyer like
Correct.
yourself. So I just want to make that clear, is that as an employee, you should contact someone like Neeti fairly shortly thereafter the incident happens to get her or another lawyer's advice of what you should do in the situation and to craft the questions and requests that you're going to have for your employer.
So I think a lot of people don't do that because one, they don't know which lawyers to go to, and two, it's just they assume it's going to be $500 for 20 minutes. So what does that kind of look like if we do need to go and ask a lawyer about something?
I mean, I can tell you if somebody wanted to consult with me, I used to do 1 hour consultations for a flat fee, and it was less than $500, and it was an hour, and I usually would just consult with them, and they would draft it, they would do everything, but I would empower them to say think about just what I just did, think about these things, what are you looking for, be articulate, articulate those things in your writings.
So just to follow up on Lane, you may want to, I get this because the Me Too movement has spawned a lot of people coming out and coming forward. I'm a lawyer too, for employers. We have people coming 10 years later.
Yeah.
So you may just want to mention statute of limitations for any
Yeah.
EOC so they know how long they have to bring a claim.
Right. So from the employer side, I don't think you have an obligation to do that. And from the employee side, you're not going to.
You have 300 days from the last bad act. So if it's been pervasive, then generally you can bring it up. Because if it's happening every week, then the 300 days never ends.
Thank you both so very, very much.